Thank you, everyone. Please be seated. We are now going to have the oral argument for the case of Lennette versus State of Iowa et al. And Mr. Diaz is here, and you will begin. Thank you.
May it please the court, counsel. My name is Martin Diaz, and I, along with Natalie Cronk, represent Andy Lennette in this appeal. We protect children better when we hold DHS accountable to its statutory obligation to conduct a comprehensive investigation. Certainly, the legislature places faith in the Department of Human Services to do exactly that. And in many respects, the investigative process is the linchpin to protecting children from abuse. The issue presented here is whether, under the facts and circumstances of this case, whether the plaintiff, Mr. Lennette, can bring a claim against the Department of Human Services and its employees for an abdication of the investigatory process. The facts of this case are lengthy and are set forth in the brief, but I think it boils down to three pieces of the puzzle. One is, who did they investigate, who did they interview in the process? They only interviewed two individuals. They interviewed a mother who was significantly involved in a bitter custody dispute, which included her taking her children out of the state of Iowa surreptitiously, and a 5-year-old child that was being manipulated. Yes, Your Honor.
You mean for the purposes of gathering that ex parte removal order?
And in fact, in this case, Your Honor, beyond that is there were additional 21 people that were made available to the Department of Human Services, and they interviewed.
Parte removal, right? Well, how about, I want to know exactly what was the evidence to get the removal, the initial removal?
The evidence included an interview with the mother, and it included an interview of the child through the CPC process.
Isn't that pretty common, that might be what generates an ex parte removal, is that kind of evidence?
It certainly is one piece of the puzzle, but I don't believe that you should limit yourself to saying if you do those two things, you have somehow complied with the obligation to investigate.
Those things, I mean, I've been in those shoes many times. If I'm going to make a mistake at that juncture, apparently somebody thought those two things were credible. That's why we are obligated by statute to immediately have another hearing afterwards. And I'm leading up to, your client waived that initial hearing, which would have kept things on the fast track. So help me understand that.
From the and I think in ways, the way I certainly look at this case is that there are sort of two tracks along. One track is you go get an ex parte order and you have that process available to you. The other part of the puzzle is the statutory obligation to conduct a comprehensive investigation, which includes.
I don't see that in the statute. The statute requires an investigation, and then has a 1, 2, 3, 4, 5, 6, 7. And 7, interestingly, is the department may request information from mandatory reporters, for example. Now, you're saying there was a violation of the statute for a couple reasons, I guess. One is you say it requires a, quote, comprehensive investigation, and I just don't see that in the statute. And secondly, as I read through the page and a half of code, I wasn't sure I saw a specific provision of 232.71B that was violated here. So help me out on both those points, if you would.
With regard to what I could describe as comprehensive, and I think the court, I believe in the Grant case, described it as comprehensive evaluation process, is in part 232.67, which talks about that this is sort of the sort of overriding principle of the child abuse assessment process. Talks in terms of ensuring the thorough and prompt assessment of these reports, and so I think that's part of it. The other part comes from the administrative code that sets out the obligation to, I believe There are places where it says the attempts shall be made to conduct interviews, evidence shall be gathered from, and then it lists a bunch of information there that it could include. During a child abuse assessment, evaluation of information shall include an analysis. There are a lot of shalls set forth in the administrative code.
As I understand what we're here on now, it isn't really a negligent investigation claim. You've got a couple of intentional tort claims, and then under the constitutional claims, you've got substantive due process, which is usually a shock the conscience type of thing. And you've got procedural due process, which I think, as the Chief's question pointed out, your client had a procedure that he elected to forego, and a procedure that might have immediately cleared his name and gotten his kids back. So, you know, explain to me, what is the constitutional violation in this case?
The constitutional violation, obviously, he has a right to relationship with his children. And in terms of the process that guarantees whether or not he's going to have a fair opportunity is going to be all dependent upon the nature and extent of the investigation. And in this case, our contention is that the investigation was effectively non-existent. Once you get past that initial phase of interviewing a mother who's got some clear conflicts of interest as she wants these children, and then secondly, the CPC interview, which doesn't form on its own a conclusion by the CPC folks that there was any particular abuse of these children. What you have is everything is dependent upon how well the DHS conducts its investigation. And so the constitutional violation occurs when the DHS fails to carry out its statutory obligation, and in the process, Mr. Lennette and his children are harmed by that process.
Is the tort arising solely out of the post-removal failure to investigate, or are you alleging the pre-removal investigation is also tortious?
That the state's contention is that sort of that the entry of the order on January 16th constitutes sort of the bright line, and everything has to occur before. But I think the focus that we've had on it is that irrespective of what happens in that process that's started with the ex parte order, the department has an obligation to conduct, the statutory obligation to conduct this investigation. And that ultimately bleeds over into what occurs. So if you don't do an adequate investigation and all you do is you say, well, we have an initial piece of information that suggests that this child needs some intervention and we're going to go ahead and take those steps, that doesn't alter the obligation to continue that investigation and to look for all of the things that are necessary.
Are you alleging that the failure to adequately investigate pre-removal is independently tortious? So let's assume that your client would have exercised his right to the removal hearing and everything would have been restored to the status quo before removal. Is that a tort?
Well, I think our contention is that the entirety of it is a tort. I think that there's pieces of that puzzle that relate to the initial removal. For example, the way this allegation was made is it was made at the emergency room department at St. Luke's. And if they had simply talked to the emergency room personnel, they would have found out that they didn't believe the allegations of the mother. Now,
Sure, you know the record better than I do, but go back to the adjudicatory hearing. Certainly that investigation was brought up at the adjudicatory hearing.
present during that original.
If he's complaining about DHS's work. My question is, at the adjudicatory hearing, did Dad present the evidence that he's saying was backing him up, that DHS was apparently ignoring? Did he bring it up?
My understanding is that at that point in time, they requested, they agreed to continue this until he could put together all of the information that was necessary. He had,
Removal, but what about the adjudication? Did they keep continuing the adjudication too?
Your Honor, this is where I'm not an expert on the juvenile process. When you talk adjudication, you're talking about the process all the way that went through December of that year.
Official action by the court that says we are going to take jurisdiction of this case. The child is a child in need of assistance.
Sometime in the latter part of January, if I'm remembering the record correctly. And my understanding is that at that point in time, counsel for Mr. Lennette made the department aware of all the concerns. I believe there was an email to that effect. I want to say it's January 23rd, but I'm not going to, don't hold me to that specific date. My understanding is that that was in conjunction with the decision to allow the status quo for the time being until all of the information could be provided to the DHS for purposes of an investigation.
Here's where I'm coming from in sort of a big picture. Am I correct that it looks like the actual adversary proceeding, the trial didn't begin till April, and then evidence was presented kind of in the spring and the summer, and then the juvenile court didn't issue a ruling dismissing the China and clearing your client's name until December? Is that right?
Correct, Your Honor.
I mean, if it took the judicial system and your client that long to go through that process, how can you fault DHS for not having uncovered all this information back in January when they had to act on an emergency basis?
And this is, I think this is where we're getting to. As part of that process, they have to go back and they have to do an assessment within 20 business days, and then they can ask for an addendum for additional time. They had that opportunity in January, February, and March of that year before we get into testimony being taken at the juvenile court hearing. And in that entire time, they didn't talk to 21 witnesses. They didn't look and ask for and obtain multiple medical records, therapy records, school records, court records, police records. None of that was done during that time frame. That's the necessary part. That's the part that the legislature expects DHS to do. And if you don't do that, then how are you going to expect that an individual can we protect children in that context? Because the children were being harmed during this process.
Hearing can be bumped down the road as long as parties agree and there's no complaints. But the actual process of getting that assessment done, there's some hard and fast deadlines that worker has to accomplish. So let's assume that assessment came down. Was that challenged ever administratively, do you know? Did Dad ever challenge at an administrative level what was done at the assessment level?
I believe I was going to say, I thought it was, but I wanted to turn my co-counsel. My understanding is yes, that was challenged in that process as well.
Let me ask this question. You cite two common law claims, I think, intentional infliction of emotional distress. We talked about that a little bit. And you also claimed intentional interference with custody. And we do have some case law on that. If we find that those intentional claims as a matter of law are not present, I know that's an if, but where does that leave you? If we find that there's no, I mean, maybe there's willful indifference, maybe, but assuming we say no intentional tort, where are you?
Depends on why, right? If it's because you're going to grant immunity, a statutory immunity, or you're going to grant Chapter 669 immunity, sovereign immunity here.
Supposing we say intentional infliction isn't here because it's not sufficiently outrageous, and then we say interference with custody doesn't apply because that refers to third parties interfering and not the state. Supposing we take that position, where does that leave you then?
Constitutional claims, and then we need to, at that point, establish, and I think this is where we get into an area of law that we don't have definitive answer for exactly how we're going to be analyzing these cases going forward. But presumably we would be going along the lines of what we talked about in Baldwin, which is it's a negligence standard, but there may be, depending on the allegation, something more required in each case.
Keep pressing it a little bit, you understand, but okay, so we're in the constitutional arena. Due process is something that you've raised, but a substantive due process claim more or less turns on whether it's outrageous, I think. I mean, maybe we can challenge whether we're going to use that kind of standard or not, but generally, a substantive due process claim requires outrageous conduct. That might be out. Procedurally, procedural due process, I'm trying to figure out where your claim might be there because you had an opportunity for a hearing, you waived the hearing. What process is left in your due process claim?
As I point out in the brief, at first blush, you might think because they had this whole hearing process that he got procedural due process. But the process is all dependent on the investigation. Again, we're talking about a hearing process that truly begins in April, but all the workup is necessary to be done in January, February, March. If you do your job correctly, you don't need the judicial process at that point because you have conducted a thorough investigation and concluded that this individual, that this child was being manipulated by the parent. So that with regard to the substantive due process issue, as I pointed out in my brief, I question whether shocks to conscience should be raised. One, because it seemingly would be inconsistent what we talk about in Baldwin, and two, because here you have the time to sit and think about it and analyze it, unlike the scenarios that we tend to get in those cases where you have a split-second decision made, typically by law enforcement. So I see that my time is up, and thank you, Your Honor. Appreciate it. Thanks.
Thank you, Chief Justice. May it please the court, counsel. Let me just dive in by the questioning. One of the things that I want to emphasize is the district court dismissed this case on multiple grounds, and the court ultimately said that the underlying claims, whether common law or constitutional, on this fact record, on these claims, were without merit. But I want to shift, because I agree with that, and you could obviously affirm on that basis. But I want to go back to some of the questions about the process, because one of the real important issues to me, to the state, to the Department of Human Services, is this question of immunity, and in particular, the question of judicial process immunity that Justice McDonald wrote about in the Venkis case, that the minor case talks about. And I suspect some of the questions you're asking deal with the pre and post removal question that might relate to that. So I want to shift back to question, Chief Justice, that you asked, which is about the juvenile justice framework, in particular for child abuse cases. And one of the things that's unique about it, and it was referred to in the minor case, is DHS has this responsibility to do intake and assessment, but also DHS is got the power or the ability to go to court on behalf of the state, both by filing a China petition, because it's one of the persons that can file a China petition, but most importantly to this case, they can go seek an ex parte order removing the alleged abuser. And that's what happened in this case. And so that was the initiation of this proceeding, really. And also, if you look at the nature of the claims here, regardless of how they're characterized, the alleged injury here is the removal of the father from the family home and the continued separation.
That is a removal. I don't care if it's the dad that's booted out or the child that's physically removed.
The way it works, it's called a removal. I mean, although, and I think that the district court in granting the ex parte order kind of referred to it that way. I mean, the statutory scheme under, get my statute right, 23282 talks about removal of the abuser or alleged abuser from the family home.
Our questioning focused on the claims. You want to focus on immunity. If we're talking about immunity, didn't we say in minor that the DHS worker is not absolutely immune to the extent they're a complaining witness, which is the situation here?
I think you did say, the court did say complaining witness as a distinction, but I think the big thing about minor is it talked about the functional approach, which is what Venkis adopts for constitutional torts. And if you look at minor and the analysis in minor and the discussion in minor. And if you look at the facts of this case, I think it's very important to note that in minor, the court talked about if the DHS person had actually filed the petition, that would be protected because of the assessment.
And is protected. But the suggestion of your opposing counsel is that, well, there's a difference between investigation and filing a petition. And why don't you explore that? Yeah.
As you correctly point out, the statute he refers to is the assessment provisions. It does have a lot of stuff in it, and it's also clear that it's not even required to have an assessment to file an ex parte request for removal or to file a China petition. It's something that comes later. But I do think that the ex parte request, in this case, you can look at the actual document that was filed, it was a request made by the Department of Human Services because they are empowered to do so under this statutory scheme. The social worker signed it on behalf of the agency, but the agency initiated the request for the removal and the ex parte order pursuant to their statutory power. So if I can answer your question, I think that falls into the area that's different than complaining witness or ordinary witness. Even in minor, talked about that essentially being the act of a prosecutor, and that the state becomes the prosecutor for purposes of this ex parte rule. I also think that with regard...
That language in minor was wrong, or?
To the case in minor. So I think the language says what it says, but it characterizes Grab in that case as a complaining witness because two things, because her affidavit was attached to the petition, which isn't the same thing as this request for an ex parte removal, which is actually filed by DHS and signed by Melanie Siver. But the court expressly discussed the difference between evaluating the evidence for its sufficiency, making the decision to initiate a proceeding or continue a proceeding, just like you did in Venkis. You talked about the core of the prosecutorial or the judicial immunity is making decisions about whether or not to initiate. In this case, all the alleged injury comes from the ex parte order. He ultimately waived his hearing, and that remained in place because he agreed to it. That is the event that they're complaining of, regardless of how they characterize the underlying facts. I'm sorry, I interrupted Justice Appel twice, so.
Okay, so I think that's just fine. But, I mean, I'm completely threaded with everything you said. But there is a notion in the case law that investigative processes are different than the actual decision to prosecute. If the universe of facts were the little girl statement and mom's statement, and that's the universe of facts, you know, there's probable cause to move forward and seek an ex parte order and so forth, if that's the universe. But the claim is that the investigation was inadequate. And I will tell you, I counted the number of mandatory DHS reporters that looked at this case. There were 9 of them, and none of them made a report of abuse. I mean, we go through the various therapies and so forth. So it's pretty unusual, I must say.
To be frank, they're making a decision. But
the case law suggests that investigation, I mean, it's maybe an artificial division. I mean, it's kind of hard to figure out what's investigative and what's prosecutorial. But the case law suggests that there is a difference between investigation and decision-making. And there's a lot of reason to think that if they would have dug in this file at all, if they would have called Dr. Alls, I'm not sure what her name was at the very beginning, who suspected Munchausen, they would have called therapist V, who interviewed the little girl and said, boy, she says she didn't say anything about it, and I talked to mom and said it wasn't there. We go through the list of all the people, then the whole file would have looked differently. I mean, I think that's the thrust of, yeah, sure.
on the factual basis, I mean, the timeline's important. This occurred in a 3-day period. A mandatory reporter who did report reported at 7:30 in the evening on the 12th. It reported physical, vaginal soreness and a frank complaint of sexual abuse. They reported, it came in, it was assigned, they interviewed the young girl and her mother. They used the CPC process, as the Chief Justice points out, which is set up with professionally trained people to do the interview, not only of the alleged victim, but then ultimately they did a separate interview with the siblings, and they had a nurse on site, and they had a family advocate on site, which is a standard process. They determined that there was enough credible evidence of abuse that they sought an ex parte order. You can scour the record for anything that plaintiffs say that they could or should have done in that 3-day window before they sought the ex parte order. The rest of it is after the ex parte order, frankly, after he waives his right to a speedy hearing in which he could have raised all of this, and they start providing information. And so the argument really is, well, in doing the sexual abuse intake and evaluation, you know, they should have just common sense walked down the hall in St. Luke's and talked about, I mean, let's keep in mind that this statutory framework makes these reports absolutely confidential by law. And so they're acting on what they have in the report. It's from a mandatory reporter. They go through all the normal steps. They make the decision, because this is what I want to talk about, having followed the process to file a request for an ex parte.
There was no county attorney involved?
Look at the filing, Your Honor. It's Appendix 77, and it's styled an affidavit submitted to the Lynn County Juvenile Court by the Iowa Department of Human Services. And that's
Almost like a document, an exhibit by the county attorney. What's the county attorney's involvement? Many times these are not reported.
as far as I know, based on the record, because I only know this case based on the record, there's no other record of any proceeding with regard to the ex parte request other than this request and the court's order. And the court's order does not refer to the county attorney. It just says the Department of Human Services. But on the same day, the county attorney did file the China petition, and the county attorney did attach the very same affidavit to the China petition that was used to initiate the ex parte request, Your Honor. Does that answer your question?
Too, for it to be the exact same document, just repeated in the petition. I'm just trying to wrap my head around the fact of DHS going straight to a judge and not involving a county attorney.
I think the statute requires them to and gives them the ability to do so under the statute. They can file, according to the statutory framework that we're talking about, expressly says any person authorized to file a petition under the China provisions may submit this request, and it expressly identifies the Department of Human Services as a person entitled to do it.
I guess I'm looking at the practical aspect. I can't find anywhere in here, the record's so dang big, whether or not there was actually a county attorney in this case.
Answer like why or the timing on that, Your Honor.
If we allow this lawsuit to go forward, will it motivate DHS to do better investigations, or will it scare them off from removals and put children at greater risk?
I want to talk about immunity. This whole process, this whole case, I mean, these important issues should not be, decided on kind of artful pleading of trying to carve around exceptions and immunities, and that's what you see in this case. I think the judicial process immunity is very important here. The court recognized it in Minor. You recognize it in the Venkis case and referenced the Minor case. It should apply to these proceedings because it's important. There are safety valves, as the court has described both in Minor and in Venkis, because of the judicial process.
In large part by reconsidering the Godfrey jurisprudence rather than parsing through Minor and the application of the immunities in this context. I know the state asked for that in its brief.
Yeah, we did. I mean, absolutely. I mean, one of the things that happens, and if you look at the layered argument in this case, both with respect to absolute immunity, but also with the fundamental tort immunities in 669-14 that were expressly carving out abusive process, malicious prosecution, deceit, and misrepresentation, which is the source of all this. I mean, it's this thing that lies outside that framework that creates litigation on all these issues. So one way to solve it would be to limit Godfrey or overrule Godfrey, but the other way to resolve it in DHS cases would be to follow Venkis and Minor and say this is all intimately associated with the judicial process under Chapter 232, and absolute immunity should apply, and I'm out of time. Thank you.
Please the court. I want to talk a little bit about the concept of the waiver of the hearing. I think my understanding, talking with co-counsel, is that the hearing was set for 30 minutes. There was a request to continue the hearing so that DHS could conclude its investigation. And that effectively is the argument that we make, is that that never happened. The investigation never got done, which sort of dovetails in part into the argument about judicial process immunity. Here, there is a statutory obligation to investigate, and that is what we are arguing didn't take place here, and that's the harm that occurs. The concept of the judicial process immunity, we only get into that if we start to parse out whether or not somebody violated something specific that was related to the judicial process. Here, the requirement is not tied to the judicial process. It could be. You could have two parallel investigations, so to speak, or parallel environments. The environment we're talking about is the environment of investigation, which is required by the statute to be done. That has to be done regardless of whether or not a judicial hearing is scheduled, or a China petition is made, or a removal is requested.
That at least at the initial reporting stage, that's confidential, and that DHS has to act on the information received and can't go out and investigate those claims at that point in time.
The initial complainant here, there were essentially two mandatory reporters. One was provided by the therapist for whom mom went to. The second was when mom was referred to go to the emergency department, she was seen there by a physician's assistant who was prepared to testify, and did testify eventually, that he didn't believe the allegation. He thought that this was all made up and that his staff had talked about it. Though they, in turn, said, we're not going to question this child because we're going to contact DHS and advise them of what's going on. And so they made the report. So while there may be a mandatory reporter, in this context, they were the person that they could talk to about the specific claims that he makes that are deemed confidential. In other words, they're not confidential here.
From a typical case involving removal, are you saying that DHS is obligated in every instance to go back and interview all of the people referenced in the initial complaints or allegations of abuse to confirm or deny them to the best of their ability?
From reading I'm sorry, did I cut you?
That's your position, that they are required to do that in every case?
Well, I think when this is the discussion that we've had, I certainly have had the discussion about, where do you draw the line? The investigative process is set forth by the statute and by the administrative code. So they are obligated to do certain things with regard to investigating, including speaking to people about what they may know or may not know.
3-day period. I think that is definitely the springboard for everything else here. I'm imagining, especially sex abuse, and I understand that this case was dismissed, that there was no finding, but up front, that's the benefit of the rearview mirror. Up front, the allegations that were made, if they were true, I as a judge, I as a DHS worker, I as anybody else, would not want even 3 days to go by, not even 1 day, because the allegations are that somebody who lives in that home is sexually abusing this child. And so isn't it reasonable for things to be on the fast track, and that's why there's an ex parte process, and then it gets fleshed out after that time? I'm just trying to figure out, what do you think DHS should have done different in those 3 days?
I think there were things that they could have done ahead of time. For example, the CPC interview, the examination never confirmed any physical.
To be made right now to protect the child. What needed to be done before the removal? Those things will happen once the child's removed. They can take a breath and go do the investigation. But in that upfront, what do we do to protect this kid now? What should the state have done different?
You know, my point, if I may, is I think there were things that could have been done. But I agree with you. I think during that first period of time that we play safe, right? But that is entirely dependent upon the obligation to conduct a complete assessment. If you don't do the second part, what are we doing with the first part? You know, and that's the problem I have.
You know, that sort of strikes me in looking at the record. I mean, and your client had, the attorney your client had at the time is not either of you, but initially your client's refusing to talk to DHS, and that would be the most relevant conversation or piece of the investigation they would want to do. Your client's handing over information saying, talk to this, talk to this, talk to this, but don't talk to me. And that, what position, you know, does that put DHS in? Or more exactly, does that, when DHS doesn't talk to all those people, does that rise to the level of outrageous conduct?
To the client in order to, in deciding whether to remove. So, and if they had, and he says, well, I didn't do it, that doesn't get us any closer. What he did is he's saying, look, there are other people who can vouch for the fact that this individual has taken my kids out of the state. This individual has made many efforts to try to manipulate the children into saying things. She's tried to gain information regarding sex abuse and how that sort of looks. So there were other people that would provide it. You know, whether the client decided initially to be interviewed was in part dependent upon how extensive is this investigation going to be. Are they going to look at the people that we're talking to? And when he met with them, he provided them all kinds of information to allow them to corroborate any of the allegations that were made. And they didn't even look at any of that stuff. So I think that's the difficulty that we have, and I'm way past my time, Your Honor, and I appreciate it. No, it's okay. Thank you so much. Appreciate it, Your Honor.
Of Lennette versus State of Iowa is hereby submitted, and court is adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.